The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome to the members of the Ray Society. Thank you for being a part of our afternoon. There are two cases that will be submitted this afternoon. Those cases are Gregory Baldwin versus the City of Estherville and others. And the second case is the Iowa Supreme Court Attorney Disciplinary Board versus Sandra Esther Suarez. Now that last case is now submitted to the court without oral argument, and we'll proceed to hear the arguments in the Baldwin case. Mr. Phillips.
May it please the court. Counsel. My name is Doug Phillips, and I represent the appellant, the City of Estherville, in this case. In Godfrey versus State, this court held that the Due Process Clause and the Equal Protection Clause of the Iowa Constitution are self-executing. In that case, concern about dampening the ardor of the governor and other public officers in the exercise of their duties was raised as a concern in one of the amicus briefs. This court said that the doctrine of qualified immunity is the appropriate vehicle to address those concerns, but declined to do so, stating the issue of qualified immunity, however, is not before the court today. This afternoon, that is the only question that is before the court.
Ask a point of clarification on that. The way Judge Bennett framed it, is it just yes or no? Or if we decide there's a doctrine of qualified immunity, are we supposed to say what the contours of that doctrine are?
I guess my expectation was that it would be yes or no, but my hope was that we would also get the benefit of the court's thoughts on what the contours might be.
Let me ask another procedural question while we're at the beginning here. The city is a defendant in counts 1 and 3, I think.
Yes.
No individual defendants in 1 and 3. How does the doctrine of qualified immunity apply to an entity? Ordinarily, it's sovereign immunity, not qualified immunity. Isn't that right?
It is exactly right. I was about to acknowledge the existence of one disagreement between the amicus supporters of the city's position and the city, being specifically that, where they have suggested that it might be appropriate for this court to simply decline to answer the question.
The briefs, help me here, the briefs go off on qualified immunity and raise Harlow and all the various cases from states. But in this case, really, we don't have individuals. I mean, should we address it anyway because it's been teed up, but where we don't really have an individual defendant under the state constitutional provisions?
Here is my thought on why we need an answer to that question. It's important to view how we got here in the context of what the pleadings are. As the court has pointed out, it's counts 1 and 3 that are still alive. Both of those claims exist only as against the city, raising causes of action under 2 of the provisions of the Bill of Rights, and seeking relief on the theory of vicarious liability for of the city's officers. We need to know if the doctrine of qualified immunity exists in Iowa.
But it's a different issue. The issue as to cities is really, I'll call it by way of shorthand, I'm sorry, but Monell is the key United States Supreme Court case. Monell basically says, well, sovereign immunity does not extend where there's a city policy. I'm giving you a shorthand here.
I understand.
You know, if there's a city policy in place, sovereign immunity doesn't apply. Among the states, there's a division as to whether sovereign immunity applies against entities. There's 4 or 5 states that say no, not at all. And then there's, frankly, a wide variety of approaches to the question of sovereign immunity. But that's a completely different question, it seems to me, than the question of qualified immunity with respect to individuals. So it strikes me that we're asked to give an interesting advisory opinion. But ordinarily, I guess we don't do that, or there's some reasons for caution before we do that. Help me out.
The reason we need to know is because there are no Manila allegations in counts 1 and 3. It is strictly an allegation that the officers knew or should have known they didn't have probable cause, arrested this fellow anyway, and therefore the city is vicariously liable.
Manel involves, as I recall, isn't it, a suit under of state officials under the U.S. Constitution under 1983. What we have here is a direct claim under the Iowa Constitution against the city. So, I mean, the question is, I guess if we could, whether we call it qualified immunity or governmental immunity or modified sovereign immunity, is there some kind of immunity that ought to be there for a direct constitutional claim against the state or a political subdivision of the state under the state constitution? That's my question.
The city is not urging this court to adopt qualified immunity and apply it to municipalities. Why I think we need an answer to this question is because of the vicarious liability analysis that the trial court is ultimately going to have to engage in order to decide if these two remaining claims live or die. Specifically, what I'm referring to is if these two officers, if this court were to adopt what I'll refer to as the federal version of qualified immunity, and Judge Bennett were to apply it consistently, as he has with respect to the federal claims, then those two officers are immune from suit. It's not an immunity against exposure.
Oh, I don't think that's quite right, if I can push back. I mean, Owen v. City of Independence is a key United States Supreme Court case, and it says there's no claim of qualified immunity against an entity. And this is federal law. So it's saying that Harlow and all the various cases that talk about individual qualified, that's not the issue. The issue with respect to an entity is the different issue of sovereign immunity. Some jurisdictions have vigorous sovereign immunity, but allow no immunities for individual officers. Some of them are a mix. But it seems to me it's not the same issue really at all.
In 99% of the civil rights cases filed arising out of law enforcement activity, there is what I referred to earlier as a Manel allegation against the municipality. This is the unusual case where there is not. There is simply the vicarious liability argument. The question for Judge Bennett will ultimately be, assuming that we have qualified immunity, if the actions taken that give rise to the vicarious liability claim are taken by people who can't be sued, is it appropriate to apply vicarious liability at all? I understand that this court in Tort Claims Act cases has said that vicarious liability does indeed apply to the state, and that the mere fact that a volunteer, for example, is immune under state statute doesn't protect the state against that claim. I think the argument will be in federal court that those cases ought not to apply because the rationale for providing qualified immunity is in part to protect government employees against the disruption of litigation, which is why it's immunity from suit and not simply protection against personal liability. And that same disruptive potential will apply to the city. And for that reason, we need to know if they're immune so that I will know if the vicarious liability argument that I've summarized is one that needs to be made.
I understand your position. Thank you.
The qualified immunity that the city is asking the court to adopt is a qualified immunity that shields government officials from civil damage liability for discretionary actions that do not violate clearly established law or rights of which a reasonable person would have known. In order for the plaintiff to avoid the application of qualified immunity, he will have to show a constitutional violation and that the right was clearly established at the time. The policy reasons that all federal courts and some state courts have enunciated in connection with qualified immunity include allowing government officials to the freedom to make reasonable, if mistaken, judgments, to provide notice to government officials that their conduct is unlawful, and otherwise to show them where the, in other words, to show them where the line is, to ensure that talented candidates are not deterred from public service by the threat of damage suits, to discourage government employees from acting not out of an exercise of their discretion, but out of fear for their own financial well-being, and to balance the need to hold public officials accountable with the need to shield them from the distractions of litigation when they perform their duties in a reasonable fashion. The city's argument, in a nutshell, is that these same public policy considerations don't change, they don't disappear, simply because the focus shifts from the federal Constitution to the state Constitution. All of these same concerns exist in the context of state court constitutional litigation. And for that reason, the city of Estherville urges the court to adopt what I've referred to as the federal body of law that relates to qualified immunity.
Well, the federal body of laws are kind of a recent development, particularly in Harlow v. Fitzgerald, 1982. But Harlow was a dramatic departure from common law. The common law, as I understand it, actually, for fundamental violations, there was no immunity. And for ordinary tort, a good faith type immunity. In the major Wilkes cases, they were celebrated back at the time, but that was a nasty search and seizure case in England. You're familiar with it, I'm sure. But it was the Watergate type case. It was internationally known, and substantial money judgments were imposed for Lord Halifax's 50 soldiers trunching through various private quarters and looking for stuff. But at common law at the time of the federal Constitution and even the Iowa Constitution some 50, 60 years later, immunity did not exist for fundamental violations. Why should we read one in now because of modern day perceptions of policy?
Because modern day perceptions of policy are appropriate for modern days.
In Butts versus Economo, which I think is the first U.S. Supreme Court case that said you get qualified immunity in the Bivens action, which is really the correct analogy, I think, not 42 U.S.C. 1983, because that's suing state officials under the federal Constitution. We're talking about suing government officials under their own constitution, under that government's constitution. In that case, they did say that immunity was long-standing going back to the Republic. So I don't know. I guess we have to sort that out, right?
Well, I wish I could say definitively when immunity was first became generally accepted. I can't.
Immunity for ordinary torts was established. The question that historian would ask is, well, what about for a fundamental constitutional claim? And we can debate, I guess, the history. But let me ask you this. There are a number of different variations. Justice Mansfield started out with this question. I've canvassed the states that allow private causes of action. And I think maybe 6 or 7, and don't hold me to the number, but 6 or 7 follow Harlow. 8, by my count, have no immunity. And then a handful, and specifically Minnesota, adopts what it claims is a common law approach. And it has a two-pronged approach, saying that it must be objectively, the conduct of the police officer must be objectively reasonable, and there's also a subjective component. Why should we pick a more rigorous federal standard when a lot of the states have gone another direction?
I believe the answer to that should be that because it's the most well-developed, there are substantial numbers of opinions to consult, varying views about how we get from the beginning of that case to whatever the holding is. And so just given the sheer numbers, I think the resources are greater. I see that I am out of time.
Mr. Phillips, thank you. Mr. Bjornstad?
Thank you, and may it please the court, counsel. Greg Baldwin, I'm Jack Bjornstad, and I represent Greg Baldwin. Greg was arrested, and he had broken no law at all. The rights we're here talking about today are specifically designed for this situation. These are the people's expression of what the government can and cannot do. And so for him to be arrested and put in jail and everything that entails, and that's where we start in this case.
I mean, the one thing, this is a little bit of an unusual case because it's a certified question. So to some extent, the facts don't really matter too much because we're answering a general question of law. So are you advocating for strict liability then, no immunity for any constitutional violation, regardless of the good faith of the or reasonableness of what the officials did?
Well, I think that you don't find any exceptions in the language of the Constitution. I think that when the framers came together as the voice of the people, they didn't put these things in. They certainly could have done that. I think they would have been familiar with those concepts. They've come from the common law.
So, I mean, for example, DHS, we had a case a few years ago. DHS reporter makes a mistake, let's say a good faith mistake, and they're in a China action, and parent sues the DHS worker. She shouldn't be able to raise the good faith conduct that even though there was some interference with parental rights, it was all in good faith, or it was what I reasonably believed to be true based on reports I was getting. I was trying to protect the kid.
I think the nature of the rights is that they are supposed to be the line that you cannot cross. So whether it's a DHS worker or in this case an officer, that's the line that the government is not allowed to cross. The people are giving the government vast power in the Constitution to handle all sorts of things: child welfare, criminal law, our justice system. That is vast power over the people.
Speaking of power, what about judges? What if a judge makes a decision, improperly sentences someone to prison? What about that? Denial of liberty, a constitutional claim is brought. Any immunity?
Well, I think it matters a lot if you're talking about a violation like what we're dealing with here. If you're talking about a violation of the Constitution and those lines that the government cannot cross, then a judge who issued an order that if we all agree that would violate the Constitution. The judge really isn't acting as a judicial officer or a judge at that point. The judge is acting, outside the bounds of the Constitution. And if you start talking about immunity, that's why these constitutional rights and immunity, they don't mix real well. The lines that are drawn are supposed to be inviolable. And if you start saying, well, sometimes though it's okay, if in the right circumstances it's okay to violate somebody's rights, then the rights become kind of paper tigers.
Well, the common law had a somewhat different approach, as I understand it, though, and I'm inclined to think, at least I'm working on the theory, that some of the common law immunities might carry forward in constitutional analysis. At common law, judges were absolutely immune. And then government agents for ordinary, what were considered ordinary torts, might be subject to a good faith immunity. But others in the search and seizure context, like Wilkes and Entick and Carrington, had no immunity. Does it make sense to assume that the constitutional provisions were enacted against a common law background, or is that kind of a bad assumption?
I think they definitely had it in mind, but I really don't think that any of the drafters there at the convention got together and thought, look, if a state official, a government official, violates someone's rights, then they should not be responsible for that. Because what you have to do is you have to look at the flip side of that equation. Who bears the brunt of this? And if it's a citizen, that causes a lot of damage. It's a lot easier for a government with all of the resources that it has, unlimited resources, compared to a guy like Greg Baldwin. A guy like Greg Baldwin can't handle that. And so who should bear that when there's been a mistake, when there's been a violation, and when someone's crossed those lines? It ought to be not on the individual. And in this case, we start with that Greg's rights were violated.
Let me try this on you. There are a number of formulations of qualified immunity. There's one that requires kind of a two-pronged test. You have to act reasonably. In order for the immunity not to apply, you have to act unreasonably, I guess, in violation of clearly established rights. I mean, that's kind of the, probably next to absolute immunity, kind of a high test. And then there's another lesser test that's something like officers can't act willfully and maliciously. Why shouldn't we adopt a more intermediate test, the willful malicious? That would get you for a police officer acting out of grudge or acting out of spite or some such thing. But you might not be able to recover for a fine line violation that might exist.
I just think your danger with that approach is that you end up with kind of part-time rights. You get rights that they're good some of the time, but they're not good all of the time. Look, about 5 years ago, I got wrongfully arrested while I was actively representing a client. Now, I knew they were wrong, and I had to go and enforce my constitutional rights. Now, that almost destroyed my career and my family and my marriage. And we, of course, fought it, got the charges dismissed. Look at it in 1983, and I'm talking with lawyers, and the very first words out of the lawyer's mouth are qualified immunity. That even though I knew my rights had been violated, just like Greg here, that may not matter. That some other doctrine may come in, and that those officers and those officials that had violated my rights would have absolutely no responsibility at all. Now, I wasn't in a position to bear that, to have my career and my family brought to dust. And neither are most people. That's exactly why the people got together and said, here are the lines. This is what we want to avoid, or arrests where,
I mean, doesn't there have to be, you've talked very movingly about your personal situation, and I appreciate that, but doesn't there have to be some, kind of room in the joints, so to speak? If there is no form of immunity, whether we call it governmental immunity, qualified immunity, absolute immunity, whatever the different varieties are, then it becomes strict liability, and the temptation is the incentive is not to act, and there are situations where we want government to act, and that can be problematic too. Like I mentioned in the DHS situation, there are times we want law enforcement to vigorously investigate, and isn't that a problem?
I guess, two things. First, judicial immunity, qualified immunity, sovereign immunity. I'm not up here asking you to walk away from those doctrines totally, abdicate them, but where we draw the line is just where the framers and the people drew the line. Once you reach that line, it can't be crossed. That's what they meant, that's what they said, and that's what they wrote down. If they'd wanted to make the lines fuzzy or build in protections for officers, they would have put it in there, and they did not. And so for us to come back now and say, well, there are good public policy reasons, and there are people do good work, officials do good work for kids and for law enforcement, and we want to now say your rights are, well, they can be violated in certain circumstances like this one. That doesn't work with the protections that were laid down.
Saying the rights can be violated, the question is, do you have a damages remedy as opposed to injunctive relief or other remedies, right?
And I don't want to go back to my situation, but it's just like Greg's. An injunction's not going to help Greg, and it wouldn't have helped me. Apologies or some other common law remedy, they're not going to get the job done. The only thing you can have is a damages remedy at that point. That's it. I think in the quorum case, that it had to do with sovereign immunity, but the court asked that same question is, well, what else could we come up with?
I mean, all right, if we take that example, say North Carolina ostensibly does not have qualified immunity, but in this particular case of a false arrest claim, of Mr. Baldwin's claim, what they would hold is that the common law, the availability of the common law remedy of false arrest satisfies any need for a constitutional claim. So there actually would be an immunity from a constitutional false arrest claim in North Carolina. So that's why I think these cases need to be read carefully. They may not adopt one form of immunity, but I'm not aware that there's strict liability in any jurisdiction. Is there?
I think that the question is a little less strict liability, and it's just a simpler question of, was a person's constitutional rights violated? And if they were, then what's fair for damages? They've been put out in the common law. Justice Harlan in Bivens put the equation. The ratio is rights to remedies. If you are going to say to a guy like Greg Baldwin or a guy like me, we know your rights have been violated, but for reasons that we think are better ideas, nothing you can do about it.
But what about doesn't it make a difference, though, whether the violation was an intentional, whether the officer knew he's violating your rights versus an innocent mistake? He thought driving the ATV in the ditch was illegal.
I guess the answer is not to Greg at all. Just like in Klein with the good faith exception here in Iowa, it doesn't lessen the violation for Greg. It may be less culpable for something like punitive damages, and that's where that analysis ought to take place, in my mind. But it doesn't stop the damage that was done to a guy like Greg, the little guy. And the city in this case would be in a wonderful position to take that on.
Do you agree this is a live issue that we need to answer to facilitate resolution of the federal case, even though the city as an entity can't claim the same federal qualified immunity, but if it's just a pass-through vicarious liability, this answer will make a difference?
I do. I think it will make a difference. The action was brought under the Municipal Tort Claims Act, 670.2. And so I think what the city is trying to do is claim the officer's qualified immunity. And so I think Judge Bennett will be tasked with that, and will have a live controversy to deal with there. Coming back to Bivens a little bit, Bivens, and I'm almost running out of time here, but Bivens can be read a couple of ways, and people argue, courts argue it over, lawyers argue over it, on whether Bivens is, a true direct action on such as a Godfrey action, or if it is just an extension of Section 1983, and they're kind of, because there's language in the opinion that says if the federal law gives a remedy, then we can expand on that. And so that may be the reason that Bivens isn't quite what it seems on that point. I see my time is up. I just urge you to reject this defense of the city. Thank you.
Mr. Bjornstad, thank you as well. Mr. Phillips. Mr. Phillips, maybe I could just begin with one question following the discussion on Klein. In State versus Klein, we did reject the good faith exception for unconstitutional search and seizures by reasoning, in part anyway, that Iowans subjected to unconstitutional search and seizures would not have any remedy. How does your claim for immunity fit within our Klein case and its rationale?
My understanding of Klein is that its holding applies to the exclusionary rule. I don't think it's broader than that. There's an element, as I understand Klein, of subjectivity that is rejected in the court's ultimate holding, whereas here we're talking about objective reasonableness. And so
yeah, but make it closer to home. This is a mistake of law. I mean, as I understand it, the officer misunderstood what the statute said. And in Thornton, we said that a mistake of law is not going, the same thing applying in an exclusionary rule situation, that a mistake of law is not going to allow the evidence to be introduced. And we held that in Thornton. Now, the federal government has a little different mistake of law. And their mistake of law when they deal with their constitutional right is that it has to be a reasonable reading. I don't think you could read this statute to say that this ditch was in there. I mean, so I think under the federal standard, they'd still be gone. I mean, why can't we contour the defense based upon the violation of the Iowa Constitution and how we interpret that Iowa Constitution and as it applies when we deal with evidence?
I'm not sure this is going to be responsive. I'm not sure that it's not. I think the officers in this case made a mistake of fact. That mistake was they believed that the entirety of Chapter 321, A through M, had been adopted in 1980 when the Estherville ordinance was changed. And as it turned out,
Mistake of law. A mistake of fact would be, is it a street or not a street? A mistake of law is what the statute says or doesn't say. I mean, you can't change a mistake of law into a mistake of fact.
Let me ask this hypothetical, Mr. Phillips. Suppose the evidence showed, and this is hypothetical completely, but supposing the evidence showed the officers knew that the warrant had a mistake in it, but had an ulterior motive to arrest. He was associated with another candidate for sheriff in some local race, or, you know, some political retribution, or some bad faith motive. Layer that onto this case, and let's assume, again, for the purpose of argument, that the officers had a bad faith motive. Would your immunity still apply?
I don't think so, because the situation that the court has described couldn't ever be said to be objectively reasonable.
Except I'm keeping everything the same, all the facts the same as are shown in this case, but I'm layering on something that isn't in the record. I understand that, at least I haven't seen it in the record, but if it were shown that the officers lacked good faith, you're saying they would not be entitled to immunity?
I prefer to use the phrase objectively reasonable. I know that sprinkled throughout the federal discussions of qualified immunity as developed, it occasionally is even referred to as good faith immunity. I think that's a mistake. I don't.
Well, the earlier cases have good faith immunity, and then they abandoned that later when they restructured the immunity. Okay.
I do not believe that it would be objective, that one could conclude that it was objectively reasonable for the officer to do what has been described if we layer on those additional facts. Justice Mansfield posited the hypothetical about the judge who wrote the order that was unconstitutional and asked whether immunity would apply. Apparently, the plaintiff's position in this case is that the only time a judge is immune is when the judge is right. That can't be the law. Jurisdictions that recognize qualified immunity do so for a reason. That reason is it provides the opportunity to balance the need to hold them responsible and accountable with the need to shield them from the distractions of litigation if they've acted reasonably. Thank you.
Mr. Phillips, thank you as well. And Mr. Bjornstad, thank you again. The case of Gregory Baldwin versus City of Estherville is now then submitted to the court, and I'll ask the bailiff to adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.